Hello, everyone, and welcome to the Pros podcast. I'm your host, Tally Shamus, and today I'm joined by entertainment lawyer Michael Duboff to talk legal issues all writers should be aware of. Michael Duboff is a Canadian entertainment lawyer with a professional focus on music, film and television, publishing, and corporate matters. He has worked with a variety of artists and creative businesses, helping to facilitate projects, performance opportunities locally and across borders, and organizational matters. Born and raised in Winnipeg, Michael's practice spans across Manitoba, where he carries on clients and representation in addition to the firm's primary residence in Ontario. Prior to working as a lawyer, Michael has worked professionally in both the music and film/TV industries, as a musician in an alternative rock band, and as a freelance director/writer/producer in Toronto and Vancouver. His passion for the arts and artists helps drive his practice and makes him grateful to be able to continue to work for and with the vibrant arts communities. So thank you so much for coming on, Mike.
Yeah, thanks for having me here today. It's a nice change up for a Friday morning, so I'm happy to be chatting with you.
So let's get right into the legal questions. What kind of legal questions do you find writers are asking most often?
Oftentimes, it really comes down to, I think, a bit of two separate buckets. On the one hand, I get a lot of writers that tend to write nonfiction or they write memoirs about their stories, and they have concerns about, writing about real events and real people and some of the legal considerations that tie into that. When people tell their stories, sometimes there are aspects of their stories that are not always positive, and so they have concerns sometimes about some of the implications of those kinds of publications. The second bucket, I would say, is really about contract work. So it's individuals that are not overly familiar with contracts, and they're looking for help either with reviewing, negotiating, or drafting of contracts.
Fascinating. Now, I'd like to dig in a little bit more on that first point that you mentioned because I find that really interesting. So, what is some advice that you would give to those that are writing nonfiction memoirs?
Firstly, when it comes to legal considerations for creatives in general, the first thing to always think about is just getting authorization in using, other people's rights. So I'm going to leave, intellectual property aside for a moment and focus on the people because that's more relevant for kind of the memoir conversation. And so if you want to write about real people involved in your life, then the first step is always to, if you're able to, is to ask for consent. If they're able to provide that consent, then that is really your answer and your shield right off the bat. And you don't really need to do much more, assuming that, consent is recorded in some fashion and it's thorough enough. But that's not always possible. People have, again, things happen in people's lives where people have falling out and events happen, and sometimes people are not able to or willing to get that consent. And so you have to consider, the legal implications from there. In particular, one of the biggest buckets on the legal side is something called defamation. So that's a tort. It's a common law tort under Canadian law. And that's essentially where you make a public statement that lowers the reputation of an individual in the public eye. So, for example, like a critical statement or something of that kind may be defamatory. And so, if someone is defamed, they may have action or cause to commence a legal suit against the person who made that statement. So that is a big talking point in these kinds of cases. But the number one defense to defamation is that the statement made was truthful. So it's this kind of balancing act and, being careful with what you're saying, the public statements you're saying. And so that's something that I often talk about with people writing nonfiction or memoirs is, how to assess the writings, especially the ones that are more critical or that could be defamatory. And to ensure that at the end of the day, those statements are not exaggerated, but are truthful to be able to protect yourself.
Right. That's fantastic advice. And now, what if they wait for the person that they are writing about to pass away? Can you defame someone that is no longer living?
Very good question. You cannot defame someone who's no longer living. And again, people do have concerns about that because people have relatives and family members and friends that may still be alive that may want to protect someone's legacy, but they cannot bring a suit for defamation in favor of someone who is no longer living. So, very good question. That is why oftentimes you see these, I may call them a little bit more scandalous or, these books that are more uncovering, buried secrets. And they're often published right after someone dies because, again, defamation no longer comes into play then.
Right, yeah, like we saw that with Jeanette McCurdy's book right
Yes,
after her mother had passed away.
exactly.
Yeah,
Yeah.
really, really interesting stuff. Now, what are some common misconceptions you think writers have about the legal side of publishing? And this can really be anything from contract negotiation to copyright, IP.
The number one thing I would say, and this again is broader than writing, it's for, all the creative industries and it has to do with copyright. It's that registration does not create copyright. That's probably the number one misconception I come across in my practice that often people think, just an established part of creating something, a creative work, is to register it in order to obtain copyright. That's not actually true. Copyright comes into existence on its own. So as long as what you're creating qualifies for copyright, which is essentially that it is an original work. So obviously you can't get copyright from something that you copy from another person. That's protected, I should say. And then you need to record it in some way. So whether it's, writing it down by hand, typing it out. If it's audio, you can record the audio. Once those two main buckets are fulfilled, you own copyright in that work. The registration really is kind of putting a bit of a evidentiary like footprint out into the world, like kind of like just saying to the world, I own copyright. But in Canada, the Canadian Intellectual Property Office, like they don't have a vetting process. They don't look into every single application or registration, and so it can be overturned. Those registrations can be overturned, and so that doesn't actually create the copyright itself.
Right. So as writers, when we're trying to protect our work, I've seen some writers, particularly when they reach out to beta readers, actually ask their beta readers to sign a contract saying that they won't steal their work or whatnot. But I mean, could you just go to Microsoft Word and get that timestamp of when you started working on the document? Would that be enough to protect you?
That would definitely be a compelling piece of evidence, I would say. That whole thing about signing a contract to protect yourself, that is actually, a pretty significant, I don't want to call it a misconception, but it's something that I kind of do discuss with individuals often, is the idea that when you're kind of going out to market and pitch your work, your script or your manuscript, people often talk about, wanting an NDA, a non-disclosure agreement, because I think that, by the other person signing that, it'll, it's a sure way to protect one's work because that individual is precluded from talking about it, from disclosing that work. Um, while that is true to an extent, I often lead people away from that a little bit. And it's because, and this is mm, less so legal advice, but the way I think about it is the industry is really built on trust. That's more than, a contractual obligation to protect something like a non-disclosure agreement. It's really about doing your due diligence. It's really about, thinking about who is the person on the other side that you may be collaborating with, working with for, perhaps many years. That more than, getting them to sign something, make sure you're looking into them, having conversations, making sure that it's someone you want to work with and can trust, because that will go a lot further than, a contractual signature.
Yeah, and I think we see that actually with agents as well, where writers are so desperate to be signed, and it's so difficult to get signed that they're applying to 150, 200 plus agents and maybe not vetting them as well as they should to make sure that they're at a reputable agency, that they're not going to, do some odd stuff with your work. So I think that's really valuable advice at every stage.
Yeah, absolutely. And with that, kind of in line with what you're saying, is it's the most exciting thing in the world when you get someone who, sends you an email, calls you and says, I want to work with you. Like I love your work and I want to make it into something more. And, that in and of itself can prompt someone to sign their name, quicker than perhaps they should. So again, again, this is not about contracts. It's not like hard law, but it's always just about, taking your time, reviewing your things and making sure like you're working with people you should be working with.
Right. Yeah. And along those lines, when in a writer's career do you think it's the right time to seek independent legal advice? And specifically, getting their own lawyer, not relying on what their agent says or even what a publisher might allege.
It's a good question. And, I don't have a hard and fast rule for this. Um, but what I often will say is, anytime you receive a contract to sign that you are not, 100% confident in understanding, don't take any chances. Make sure, like at that point, ideally you speak with a lawyer, someone who's knowledgeable to provide advice. And that's not always your agent, which I think we may touch upon in a little bit. But get someone whose expertise lies in that field. It's often around the contract to make sure you get that, that second set of eyes on contract to really reach out at that point would be a big one.
Yeah. And now, what should a writer look out for on their own when they're looking at these contracts, whether they come from agents or whether they come from a publisher?
We're talking about like what kinds of contracts, like a publishing agreement or an agency agreement, or just in general.
I didn't think about in general, but that would be interesting to touch on as well. But I was thinking specifically about an agency agreement or, an offer to publish their work.
Sure. So a couple pivotal parts of those agreements. Um, One is something called the term, which is essentially just how long that agreement operates for. That is a very significant clause, and I think it's for obvious reasons because it essentially is how long you, the writer, are tied to the other side. So how long are you tied to the publisher for? How long are you tied to the agency for? How long can they represent you? It's quite significant if it's 1 year where there's a lot more flexibility for the writer at that point, or it's 10 or 20 years or perpetual, that can really tie an individual's hands, depending on how long that term is. And tied into that kind of consideration is something called the right to terminate. So whether a party has the right to get out of the agreement then. And so it's always a bit of a balancing act with these agreements. The clauses balance off of one another. So for example, if a term is 1 year, it's kind of like a trial period a little bit. And so the right to terminate may not be as relevant. If someone can get out after 1 year, then, it is what it is then. But if the term is 10 years or 15 years, then the need for a clear understanding about your right to terminate the agreement is much more important. So things like that, it's always, if one clause is more onerous or burdensome against the writer, making sure that there's an equal give somewhere else that gives them a little bit more power. There's a lot of bargaining power discrepancy in these agreements. Well, I shouldn't say always. There are established and powerful writers out there as well, but oftentimes we're working with ones that are more in their entry level of their career or mid level, where they don't have as significant bargaining power. So it's really important to make sure that these agreements are balanced. With that as well, it's really about like the scope of these agreements, like the rights that the writer is giving up. So, for example, for a publishing agreement, does that agreement cover just one book of theirs? Does it cover their whole library? Does it cover future books as well? So it's all about, the reach of this, what's called the grant of rights. The writer is granting certain rights to the other side. And so the scope of that, I like to call it a bit of scope creep, where it's, creeping past what's necessarily reasonable. And so this is something that I would always flag for my client, for the writer. Similarly, on the agency side, we want to make sure that we have a clear understanding about, for example, what types of work or what industries does the representation cover. If it's a literary agency, sometimes it will creep into other industries, or maybe just be open-ended, where, some writers have other jobs too, or other lines of work, where we want to make sure that there's clear definition again, so that the agent ideally can't claim compensation of other unrelated types of profit from the literature itself. Um, Another big one for agency, in particular for agents, is after a representation ends. So after an agency agreement ends, there's sometimes agents that will continue to earn compensation even after the agreement's been terminated. So we want to have a clear understanding there. Maybe we have a what's called a sunset clause that compensation diminishes over time so that again that agent isn't just perpetually earning from the author, the writer, even after they no longer represent them. So those are, there's a lot more that I could get into there, but those are some of the big considerations I would say.
And I love that you bring up the term and termination first because I think that so often writers are interested in money. How much am I getting paid
Yeah,
for this? In
yeah,
rights, even, what exactly am I giving away? Am I giving away the rights to get this published? Am I giving away TV rights, film rights? So I think that, and I actually recently wrote a Substack post about this. Termination is quite possibly the most important clause in a contract because essentially it saves you if you need to get out of a sticky situation. And, along with that reversion of rights, what happens to your rights after that contract ends. And I think that it's also really interesting, to understand that you're not actually selling your work. You're not selling your book. You're selling the rights. You're selling a license
yeah.
to what you've created. So I I see why I went to law school in the first place.
Yeah. Yeah, and it is kind of like that you mentioned it that I didn't mention money at all in any of my points here because on the face of it, that's really just a business term. What we're often focused on is what I always call kind of the worst case scenario, people that we're there to identify things that you want to avoid, or if things go wrong, what happens then to make sure that, you, as in you, the client, my client, is protected. And so again, as you mentioned, like term and termination is important for something like compensation. It really is kind of more clear cut. Sometimes if there's like percentages of revenue, it can get a little bit more complicated, but really that's just, business negotiation to a certain extent. Then we're looking into like the finer terms that often the writers will not necessarily pick up on because they are focused on, the dollar signs.
Exactly. And just understanding exactly what wording in a contract will protect the writer is so important. You want that wording to be very specific, right? You don't want to, for example, allow a publisher in their discretion to decide what they have the rights to. You want to limit that by saying something like what's reasonable, something
Yeah.
like that, right? Now, getting a little bit more into things that authors should look out for, what are some, or let's say three red flags that you think every author should look out for in a contract?
Hmm. There's so many that I can think of. I've touched upon a few, but I'll try to keep it a little bit more general here. So this is more kind of advice about contracting in general, I would say. One is, and then again, this might be a third line for this podcast, is to take your time. Particularly, I say this when, you get situations where there's a bit of a time crunch that the other side say, we need to get this done today, let's get your signature by the end of the day. And when someone says, like, starts rushing a timeline, that's when I always kind of put my foot down and kind of say, like, let's actually stop and slow things down. Like it has a reverse effect for me that I always try to impart on my client. And that's because rushing things is always a bad sign for me, unless it's justified. Sometimes there is a legitimate, time consideration. There may be like a grant application or, some specific event that something is leading towards. But oftentimes people just try to rush timelines when contract negotiation is happening. And it's from my experience, it's when something is kind of being a bit hidden or something is, not particularly right in a contract that they're trying to just gloss over. They're trying to speed things through in order to get a signature. And so when someone tries to rush a timeline like that, that's when I always kind of take a step and actually slow things down to give things like a second check or to make sure that, terms are absolutely solidified before signatures happen. Because, at the end of the day, there's no reason to rush things along unless there is, a justified, reason that both sides understand. Um, that would be one point. Another one which you've kind of mentioned is ambiguity, that ambiguous language in contracts is problematic, is what leads to dispute. Because, like at the end of the day, if two parties to a contract interpret a clause in different ways, that inherently will lead to argument, and that can lead to a breakdown of relationship. And so again, clearing up any ambiguity if things are mentioned without what's called like a defined term in an agreement. In almost all agreements, you'll find capitalized terms, which is called a defined term, which means that that term has a specific definition within the confines of that agreement. And sometimes you just get, not ideal drafting where you have defined terms that are not defined. And so that can have implications again if one party doesn't understand what that's actually referring to. Um, I had another one and I think I just lost it.
That's okay. Maybe it'll
um,
come back.
the other thing too is just to remember that, writers, if you have a lawyer, if you don't have a lawyer, if you don't have someone advocating for you, you still have a voice. Do not sign an agreement to contract if you have any hesitation, if there's any confusion, if there's any ambiguity. You have a voice and you have every right to ask questions. And if you don't have a lawyer right at that moment, you can ask the other side directly like questions. You have every right to do so. If anything, it's a red flag or it's more telling than anything if that person either refuses to answer your question or does not provide an adequate answer. That in and of itself is an answer for you and, should probably have you questioning going further in that relationship, I would say.
Right. That's fantastic advice, as is everything you've said. But I'm wondering, so if a writer doesn't have a lawyer and there's a clause in an agreement that they don't quite understand, what would you advise in terms of how to proceed? Should they make sure that they're asking in writing? Can they do any of their own research? And what are some resources they might turn to for that?
For sure. Of course, there are resources online. Although I always say, anything online, make sure, as always, you're doing your due diligence with that. Don't necessarily rely on Wikipedia or Reddit or just a Google search. Try to go to sources that are a little bit more verifiable. There are a lot of law firms out there that have blogs on relevant topics. For example, like if someone were to go to my firm's website, we have free blogs on, numerous creative topics, legal topics, like sources like that, where it's people that are have verified knowledge in the industry would be places that you can rely on a little bit more than, just open-ended sources online. Next to that, going back to just the previous conversation is, again, you can ask the other side. And if you do so, definitely get it in writing. Because again, if they provide an answer to you that is ultimately not correct or leads to other issues, again, you can rely on the fact that it's recorded and you can present that in future as needed.
Okay, so let's say we've read the contract. We think we understand what it's setting out. We're moving on to negotiations. What's the writer's role in contract negotiations?
Do you mean, like universally, or what is their role like to, fulfill their own side?
Let's say that your agent is negotiating with a publisher and they're reporting back to you. Should you be involved in the negotiation process? Should you see what's going back and forth between the parties? Or can you take a step back and rely on your agent to represent you? And also, when a writer is trying to get representation from an agent, I guess even moving a step back, how much bargaining power do you have? Let's touch a little bit on those power imbalances that you brought up earlier. Should you feel like you can negotiate the clauses? And what are some clauses that generally don't get negotiated, others that maybe there is a little bit more leeway? I guess it is quite a broad question, isn't it?
Yeah, yeah. But I can speak to some of these aspects. To the first question about the involvement, I'd say it's really preferential. It's, how well, or, what your process is with your representative. So if it's your lawyer or agent or anything. But my suggestion is that, the client should always still be involved and at the very least, following along conversations that are being CC'd, even if they're not chiming in. Because again, if you have more than one person communicating at the same time from one side, it can lead to confusion for sure. But they shouldn't be just kind of like fully separate from the conversation, like in totality. Then at the end of the day, there are professional obligations that someone like a representative, like a lawyer or agent, shouldn't do anything without the clear instruction of the client. So that is, already established professionally. But then again, I can't speak to every relationship. I'm sure that there are people who have had a lawyer or an agent for, decades that they have ultimate trust in, and maybe they don't have, as closely an eye as other individuals. But, my general suggestion outside of that specific type of scenario is that a writer client should be very much involved and following along to make sure that, at the end of the day, that the conversations align with their objectives, with their wishes, and so things don't go astray at all. Your second question is about bargaining power, right?
It was about
So
yeah, it was about agency agreements and, how empowered should writers feel to negotiate certain clauses.
yeah, the main point is, regardless of what anyone else says, all contracts are negotiable. There is nothing, there's no law out there or ultimate rule that any part of a contract is non-negotiable. I say that even though there are people who will literally say this is non-negotiable, but that, is simply not true. That is, I don't want to say it's intimidation, but it's someone who is putting a foot down and is not always being reasonable, but because everything at the end of the day is negotiable. It doesn't mean you have to agree to it, to a change or a revision or request, but everything is ultimately negotiable. And this again, you'll see that there's patterns. And when I'm saying that, a lot of it is kind of circular. But it goes back to the fact that, writers all have voices. They have every right to ask questions. Is this, necessary in the agreement? Can we modify this a little bit? Can you explain this a little bit to me? Because everything can be, changed or modified if the parties agree to it. There's no aspect to the agreement that has to stay true.
Right. Now, how about if an author is working with somebody else in the industry? So let's say they're working with an illustrator or they're co-authoring a novel. What are some considerations that they should keep in mind?
For sure. Another thing that I talk about often, and it is like a little bit of a separate conversation, so it's great to bring up. Um, it's the fact that, it may seem a bit ridiculous, but anytime you as a creative is working with another individual, you should have at least a base contract or an agreement in place in writing. And the reason I say that is because collaborations, doesn't matter if it's your best friend, your sibling, you know, things happen and relationships sometimes break down, or sometimes people just leave projects. And when that happens, unless the conversation has happened, there can be ambiguity and therefore lead to dispute. So what I'm trying to say is that anytime you start working with another individual, have a conversation on the outset. At the outset, talk about some of the main, aspects of the collaboration. So such as like ownership, obviously like compensation to a degree, decision-making power, and then perhaps most important is what happens if one of the individuals leaves the project. So all of these items, if they're not agreed to, like clearly between them, any one of these can lead to pretty significant dispute, if certain things arise in future. And once those terms are agreed to, just have them written down in a simple agreement. This doesn't need to be a 20-page agreement. It can be, one page even, what we call sometimes a deal memo, something very simple, but that just represents the agreed to terms is really important. And it also is what forms something broader in the industry called chain of title that just makes sure that, the rights to a creative work flow through all the people that have contributed to it along the way. It's a very common concept in the film industry, but even in publishing, for example, if you get a publishing agreement, that publishing company will want to make sure that the writer who's entering the contract has all the rights to the work that's being published. However, if there's, an illustrator involved, and again, there's no contract between the writer and illustrator, the illustrator could contest the publication. They could say, well, I was going to be paid $500. Nothing was ever written. They were paid $300. They could contest that ownership. And that's a very simple example of how these things can get tied up very easily and why, basic contracts are very, very important to have.
So I have two questions stemming from that. So the first is you mentioned a little bit earlier how this is an industry based on trust. And, NDAs when you're getting beta partners or when you're just submitting to agents, not signing representation yet, maybe a little bit overkill. Now, I think that maybe it's a little bit easier for us as lawyers to see the nuance of, working with a beta reader is not the same as working with a co author. But can you touch a little bit on the differences between those two scenarios and when you actually need a contract versus when trust is enough?
So the beta reader, are you paying them, or are they just like kind of like an audience that's reading your work for feedback?
So there are both scenarios exist. Where you're paying a beta reader, I guess that paid beta reader would want to be protected, and you would as well, to make sure you're getting a return. But let's focus on just free beta readers, critique partners, friends who are reading your work.
For sure. So again, the answer really comes down to the trust aspect again, and I'll explain why in this specific scenario. Let's provide a few different scenarios where for this beta audience, let's say it's your best friend for one. Then let's say it's a beta platform, and I'm sure these exist. I'm actually not personally familiar, but let's say there's a platform that exists where it's established that people will submit their writing and there'll be people, beta readers, who will provide feedback. And then let's say you put a ad on, I don't even know if it exists anymore, but like something like Craigslist, where you just it's completely open-ended. There's no vetting whatsoever, and you put your written work, your manuscript up there for someone to read and provide feedback. You know, I'll ask you a question. Where do you think the change in trust is, between these three platforms?
So where you're closest with the person you're working with, that there should be a level of trust between you and a friend.
Yeah, and similarly, if it's an established platform that it's built for this type of purpose, again, people on both sides understand the relationship, I would hope. The beta readers are there because they're interested in reading things and providing feedback. They're not there looking to, rip off people's IP. Whereas the third version, the Craigslist scenario, who knows? It's the Wild West. But my point is that it's all about, understanding the risks and opportunities to each of these different scenarios and what happens when you put your IP out there, and, the reasonable risk involved versus the opportunity. Um, and, likewise, there's a level of trust in each of the different platforms or opportunities. It's similar to the scenario with like submission releases, if you're familiar. So there are a lot of platforms out there. There are, publishing companies. Similarly, if you're a screenwriter, there's production companies, and often they will open up, the availability for pitches for people to submit their manuscripts or screenplays for reading by these different, companies. And as a precursor to your submission is that a writer will have to sign a submission release. And on the face of it, these are, somewhat intimidating agreements. Um, I'm also going to contradict myself in just a moment with this. And for example, one of the clauses in a classic submission release is that the company says that they may have a project in development that's very similar or even identical to what you're pitching. And so a lot of people interpret that as, free reign for that company to essentially rip off your, your project, whatever you're pitching. And, the way it's drafted kind of seems like it is. But again, it's all about the risk opportunities like balance. That if it's an established publishing company, if it's an established production company, then they're vetted, they have credits, they're not people that are necessarily nefarious. And if they want to, work on that type of project that's being pitched, more likely than stealing it, they'll just, pay you or, have a contract signed to obtain that IP. That's the flip side is if you're a publisher or like independent producer who has no credit, has never worked in the industry, you can't even find their name online, and they want you to sign the same submission release. It's all about the context and the opportunity that's there, and looking behind the veil for a moment to see if this is like a reputable entity or individual that is less likely to violate your IP than others. Um, the contradiction I was referring to is that these submission releases are non-negotiable. Again, not inherently, but no, like something like Netflix, that they're not going to negotiate their submission release if they're opening it up to the public to submit their work for review. So again, there's a small contradiction, but it's a very specific scenario.
So I mentioned having two questions on what you were talking about before. And so my second one goes to conflict resolution. So when we do believe that someone has stolen our story, not just our idea, because we know we don't have ownership over ideas, but let's say we see a story that is very, very similar to something that we have written in terms of the plot points, the characters, really distinguishable aspects. Litigation is not ideal in many aspects. It's expensive, it's time consuming. So, what are realistic conflict resolution methods that authors can consider?
This is a tough question because it's very broad. It's essentially a whole line of law that deals with this type of matter. It's very hard to provide an answer without giving different scenarios because, again, an individual who you think has infringed your IP versus, Disney or someone much broader. It's going to be a very different answer. Litigation is often involved. The number one thing to consider with, copyright infringement is something called access. You need to assess whether that person who you think infringed your IP ever had access that you know of to your IP. So again, if it's someone who you gave your manuscript to read a beta read or something, it's very obvious in that case, and it's a stronger case of copyright infringement. If it's someone you've never come across, maybe they're in a different country, it's a tougher thing to assess because in order to establish copyright infringement, there has to be a level of access that the person had to have access to your IP in some way in order to to copy it like without authorization. But the pre-litigation course is often something called the cease and desist order, and it's it can be something, just a letter that's drafted and sent to the individual that sets out the claim, sets out the background, and asks for certain recourse. Often, at the very least, it's to stop the infringement. So, however they're using the work, it's to no longer do so. There may be a demand for payment as well, but if that is unsuccessful, then unfortunately, often it does lead to litigation through certain corporations, such as like a network, like a television network. Sometimes there are established takedown processes where, or maybe let's say like YouTube or Instagram, if you see someone who has used your intellectual property, you can reach out to the company that controls that platform, and sometimes that is another route as well. You likely will not get any money that way, but again, it's tough to say without kind of getting to a variety of different scenarios there.
Well, I can give you a scenario that I've seen come up a few times in the writing community, and that is that a writer will submit their manuscript to an agent, whether that's a partial or a full. More likely it happens with a full manuscript. And a few months later, or a year later, however long, that agent will then sell a client's book that sounds very, very similar to this manuscript that somebody else submitted. And they think, oh, well, that agent took my book and had someone else repackage it and they sold it. So what advice would you give to someone coming to you with that scenario?
I think it's a very tough scenario. It really probably doesn't deviate from, the steps I set out earlier. It's, start with a letter. If that's unsuccessful, there is the litigation route, unfortunately. Prior to both of those, it's all about, doing your due diligence with that agency. Speak to other authors that are repped by them, do some research online. If they are a legitimate player in the agency world, I would hope that this is less common. Again, I have no guarantee of that, but I like to hope that that is the case.
Yeah, yeah. Well, we all hope. Now, moving on to different types of writers. So we've been talking about traditionally published writers so far, but are there any different legal considerations that self-published writers should keep in mind?
Not really at the end of the day. Like in terms of the writing that they're doing, it's going to be the exact same considerations, because that's just in the creation phase of the work. And so the legal considerations are more or less the same. In terms of the publishing part of it, what I would say is that, the contract review is still relevant, because a lot of self-publishers will still use self-publishing platforms. So there's a lot of sites online and businesses online, for example, that, will help you to self-publish. And as such, I assume that they will have their terms of service or terms of use, which is, again, just a contract to work with that company or with that service. So always good to familiarize yourself with that, to review those terms. But subject to that, no, really not any significant legal considerations that jump to mind for self-publishing specifically.
Okay, good to know. Well, as we come to the end of this episode, I would love to ask you if there's just one piece of advice, law related, that you wish every author knew before getting into the publishing industry.
Sure. So it's going to be kind of repeating a couple of the key points that I've touched upon already today. One is, make sure you have the rights to what you are writing about. There is fan fiction out there, which is, more or less okay if it's within certain environments or with audiences, but don't try to commercially publish, say, your own Mickey Mouse story. It's not going to go over well. Similarly, if you want to write about a bad event that happened in your life, make sure that you are being careful with the way you portray it. You can open yourself up to liability. So make sure you get a little bit of a consultation or a good understanding of the implications there. Those are a couple legal points. And then more broadly, again, just repeating what I've said before, is remember that, you should always be in the driver's seat in all of these types of communications and collaborations and engagements with agents and publishing companies. People are coming to work with you. They are giving you a contract because they want to work with you. Therefore, you should remain in the driver's seat, be confident, speak loudly and without any shame, ask the questions, and, at the end of the day, don't sign anything that you are not confident is going to get you to the next level in your career.
It's wonderful. Thank you so much, Mike. This has truly been enlightening. I think that the law is so intimidating for so many people, and I really appreciate you coming on here and illuminating some of the more murky corners of our industry.
Yeah, absolutely. Well, it was my pleasure, and thanks for having me today, Sally.
And thank you all so much for tuning in. Remember to check back next Tuesday for a new episode of the Pros podcast.